I would like to start this discussion by speaking a little bit about the role of international law to address crisis. Um, Many people believe that this is the nature of international law because it has to deal with sovereign states with competing interests. However, we see the resurgence of war in many contexts today, like Europe, Gaza, Yemen, and other atrocities committed around the world. And in a recent post published on the blog of the European Journal of International Law, one of your colleagues, Professor Fouad Souarbayev, wrote that since he started studying international law 29 years ago, he never lost his faith in the power of the idea of international law, making a distinction between individual breaches of rules of law and what undermines the rule of law, but that his faith is seriously shattered today and the rule of law in international affairs increasingly looks humble. So what are your feelings on this? Maybe we can start with Lauri.
Thank you for this question. International lawyers have often spoken of crisis when characterizing what is actually happening in international relations. And there are, let's say, better times and sometimes not so good times for international law, its enforcement. Obviously, when aggressions take place or even accusations of genocide are made, and these are extremely serious problems. I think international lawyers are a peculiar group because on the one hand, our task is to analyze the situation, to be scientists, to objectively assess what is going on with international law, also its problems. But at the same time, I think since already centuries, there is also a certain commitment to international law as projects, which sometimes maybe even makes us a little bit, well, less objective, because we are also a little bit like priests of this religion and that is called international law, because there are so many people who are, let's say, into realpolitik, and I think international lawyers also by their activities, by what they do, they try to push a little bit back to bring a little bit more of rule of law into this story.
Yeah, I think I agree with Lauri. Let's be clear first. International law has to be respected. Atrocities must end. We need to put an end to armed conflict. That is quite clear. We need to prosecute those responsible of these violations of international law. But the core question is, I think, are we facing today a new situation? Is there something different from what occurred in the past? And of this, I am not convinced. Because, in fact, happiness is not part of the DNA of international law. International law is here precisely to face violations of international law and to give means and tools to victims of these atrocities to have justice. And in that regard, there may be some, perhaps today, problem of perspective. If you take the example of Ukraine and Gaza, of course, we heard a lot of this crisis today, but we are commemorating today the 30th anniversary of the genocide in Rwanda, 30 years ago. Atrocities, violation of human rights are occurring all around the world for many decades. So I'm not sure there is something new here. What is important, and I totally agree with Lauri, is to keep faith in international law. And we, as international lawyers, have a duty of optimism, so to speak, because if we do not believe in international law, nobody will believe in international law. So I think that, of course, sometimes it could be very concerning to see that international law is not respected at all in many countries, but we need to keep the project of international law alive today.
Thank you. That is very interesting. I was wondering then, with the conflicts we have seen in recent decades and those that are emerging today as well, do you think the prohibition of the use of force remains a pillar of modern society?
Yes, I think it does. 15 years ago, there was a conference in The Hague for the centenary of the Hague Conventions of 1907. During that conference, one American professor, Michael Glennon, took the floor to say that the prohibition of the use of force was not any longer a part of international law. And many people in the room said it was not true, that in fact all states still believe in the prohibitions of the use of force. And I think that the ICJ, the International Court of Justice, put it very rightly in 1986 in the Nicaragua versus United States case, where the court said that when you have states using force, but trying to justify the use of force by exceptions to the use of force, it's a confirmation of the rule and not a sign that the rule is faded away, so to speak. And if you take the practice today of many countries using force, they are trying to justify the use of force by exceptions. Sometimes very artificial justifications, like Russia in Ukraine, saying that Ukraine is committing genocide. But you have many, many other examples. At the same time, I think there are some practices today which are problematic because they are in a kind of gray area where you do not know if it's a new practice or if it's only exceptions to the rule prohibiting the use of force. And I am in particular thinking of the practice of some democratic countries, which is to use force to kill people abroad, what we call targeted killing. This is to some extent problematic because it comes from democratic countries and it is used to protect general interest or to protect human rights or to fight against terrorism. But this kind of practice could be more problematic for the rule prohibiting the use of force. By contrast, when you have clear violation of the rules, like what is occurring in Gaza or what is occurring in Ukraine, there is no doubt that the rule is still there because many countries in the world will claim that this is a flagrant violations of the UN Charter.
Thank you. What about you, Lauri? What do you think about this use of force and how countries respect the rules or not?
I think this problem of the use of force is really a central problem for international law and international order. And what I think is important to remember is that this prohibition of the use of force, that it is actually a relatively young phenomenon in international law. Of course, in the Middle Ages, there were all those just war doctrines, you had to justify it, but as part of international law that it is prohibited, it's really the first half of the 20th century, the 1928 Paris Pact or Briand-Kellogg Pact, and then, of course, the United Nations Charter in 1945. So for several centuries before that, Europe, for example, had quite sophisticated international law about ambassadors and treaties and even state responsibility, but war as such was not outlawed. So in some ways it has been a revolutionary, progressive development, certainly from the perspective of smaller states, but from the peace generally. But I mean, of course, let's say realists, they when they study the history of international law, they would say that it all develops in somehow phases, that there are certain times of peace that last maybe sometimes almost up to a century, like with minor wars, but at least no big war. But then things change in the world and somehow people forget the horrors of the last big war and then something may go worse. I agree, of course, with Mathias that there are no indications that the very, very, very big majority of states obviously supports the prohibition of the use of force, continues to support it. But I also think that, maybe coming from Estonia, it's easy for me to see, for example, things from a mid-sized state like Ukraine. I think for them, it's a weak consolation, let's say, if Russia justifies its actions with the tools of international law, and one can see that, let's say, what Ukraine can do about it is still, it's a little bit limited. It's a little bit unsatisfactory. But this has always been also part of the reality of international law, that it is far from perfection in those tools, because these are sovereign states. They don't have anything above them, and of course the size always creates an advantage. But I think that we should uphold, of course, and this is another, what we started today's conversation with, I think international lawyers definitely will keep saying, you cannot do that, you cannot attack another country.
So you both come from different countries, both in Europe, France and Estonia, but with very different histories and quite different geopolitical challenges. While international law relies on the principle of sovereign equality, I was wondering if you see any differences between how your respective countries approach the challenges of peace and international relations within international law. We can start with Lauri, maybe.
Yeah, France and Estonia are both European countries. They are members of the EU, they are members of NATO, but it's true that there are differences of them. France is one of the great powers, at least historically, one of the countries that really determined the fate of Europe and the world in several historical contexts. Estonia used to be part of the Russian Empire until 1918, and then we proclaimed independence. Our diplomats came to Paris to ask for recognition from the leading powers in 1919. And I think what I see today is that while Estonia is maybe an archetypical small state, and of course that there is a presumption of sovereign equality in international law, but I think small states sometimes face particular challenges that they have to kind of, their worries also in the context of international law can sometimes be more existential because they cannot only rely on their force. France, for example, has nuclear weapons. Estonia doesn't obviously have that tool. But at the same time, small states can be also flexible. They can be innovative. Estonia is one of the leaders in IT and cyber in Europe. There are small states can show initiative at the international scene. We know the special role of states such as Switzerland and the Netherlands in the history of international law. But even today, for example, Liechtenstein is very active at the United Nations. Estonia has, for example, supported a project in cyber and international law called the Tallinn Manual. So there are things to do, but I think the Estonian President Lennart Meri once in the 90s said that the nuclear weapon of small states is international law. I think it's a little bit maybe exaggerated, but it's still a nice metaphor because if there is anyone who is invested in having international law, not just a rule of the stronger, it is by definition the smaller states.
Thank you, and Mathias?
Well, of course, each state has its own foreign policy. What we call in France, it comes from la charrière, la politique juridique extérieure, the foreign legal policy. And each state's foreign policy will depend on its geographical situation, its economic power, its military power. There is, I think, no doubt about it. And in the case of France, of course, the fact to be a member of the UN Security Council, the fact to be a coastal state with wide maritime spaces, the fact also to be a rich country will have an impact on the foreign policy of France. Also, the past of the country will have an effect, and the fact for France to have been a colonial power still have repercussions today. If you see the reactions coming from some African countries against France today, this is the effect of the past history of France as a colonial power. But at the same time, I think we need to disconnect all these elements from the foreign policy itself, because you may have two similar countries, rich country with a big military power, etc., with two different foreign policies. If you take the examples of the US and France, they don't have the same policy in terms of the protection of the environment. So it means that even if you have similarities between some countries, each country can define its own foreign policy and can, for instance, embrace multilateral goals or be unilateral in its foreign policy. So it's a very difficult exercise to try to categorize each country and each state's foreign policy, and there is nothing which is immutable. It will depend on each government, in fact, in each country to decide which will be the foreign policy in the future.
You are both also members of international institutions. So in all these complex and turbulent contexts that we've been discussing, how do you see the roles of these institutions? Do you still believe on multilateralism? We can start maybe with Mathias, who is a member of the ILC of the UN.
I may sound too optimistic, but I am still a strong believer in multilateralism, and in particular in the work of the International Law Commission, and mainly for two reasons. First, I think that the mere fact that you have international institutions that exist is in and by itself a great achievement of international law. And to a large extent, to be is as important as to act in international law. If you take the example of the International Law Commission, this is the only place in the world where you can discuss topics of international law at the universal level with lawyers coming from all over the world, speaking 6 languages, and in fact more, working in all these languages, exchanges legal cultures and legal traditions. So in and by itself, this is very important for international law because it will foster international cooperation. In addition, the ILC has as a mandate the role to progressively develop international law and to codify international law. And the fact that the international society and the UN still believes in the development of international law is a very good achievement too of the international society. Of course, many people will say that the golden age of the ILC was in the 60s or the 70s and that the ILC is no longer relevant in today's world. I think it's quite not true, in fact. And I will perhaps take 2 or 3 examples. In 2021, the ILC adopted guidelines on the protection of the atmosphere. And at that time, many people say, well, it's just recommendation, wishful thinking, etc. In fact, it has an impact today. And we have pending cases before court and tribunals at the international level on climate change. And this work of the ILC will be very relevant for these international courts and tribunals. The second example is a topic which is currently at the agenda of the Commission on immunities of foreign state officials in case of allegations of international crimes. This is a topic which is very important to fight against impunity, and what the ILC is doing today on this topic will be important for the future and for prosecutions of international criminals. The last example is the work of the ILC on sea level rise. The Commission started the work a few years ago on sea level rise and the way it affects some small islands which will disappear because of sea level rise. You have some big countries like the United States of America which very recently changed their practice, their national practice, just to take into account what the ILC discussed on this topic. And they decided in particular then when you have a sea level rise which restrict the maritime spaces of small islands, you need to keep the maritime boundaries as they are to protect these small islands. So it shows that even a body like the ILC, which is only experts making recommendations, it has a strong impact on the practice of international law today. So yes, I am a strong believer of multilateralism today.
How about you, Lauri? You are a member of the Venice Commission at the Council of Europe. Do you share this view that these bodies can be a way of sharing legal cultures and producing regulations?
Yes, of course, I see value in bodies like that. First of all, there are, of course, differences between the bodies that we know from inside. International Law Commission is really a universal body, whereas the membership in the Council of Europe's Venice Commission is more limited. But interestingly, it also includes members from outside the Council of Europe, so it's not limited to only the region of Europe either. Well, specific feature of what the Venice Commission does is I think of it as a kind of peer review of experts from other states who are participating in these 4 states to sort of monitor or double check on constitutional developments. I mean, it's an interesting academic problem too, the interrelationship between international law, international ideas, and constitutional law. I think one famous French scholar talked about the doublement fonctionnel, that actually international law too needs domestic law to be translated, to be actually implemented in practice in many contexts concerning rights, for example, rights of individuals. Of course, so the other name of the Venice Commission is the Commission for Democracy Through Law. So it kind of highlights democracy as value. So only states who I think value that or want to take it seriously are members there. But one thing that I have learned while being member there is that the importance of these institutions is also that in many ways they are bigger than individuals. As excellent individual scholars would be, and jurists, for example, these institutions, they kind of have their own gravitas. It is easier, for example, for states to listen to an institution than simply a professor from, I don't know, Paris or Tartu, right? Because there is this collective intelligence thing, there is this representation, and there is this idea of rotation as well, that basically International Law Commission, for example, has already a history of decades, and all the great international lawyers have gone through it. Not all of them, but many of them. And this itself creates this kind of institutional gravitas that makes it easier for those bodies to tell to the states, also to some extent to tell them that let's develop things in this way progressively, or like in the case of the Venice Commission, to tell to a state that you would make a mistake if you would adopt this kind of law, because it's not actually compatible with democratic ideas.
Thank you for your answers. So for the next question, I wanted to discuss a little bit about the idea that for managing peace and international relations, we need something like a united international community. At the same time, we must value diversity of approaches and diversity of cultures, legal cultures, and so on. As international lawyers, how do you try to reconcile this? Do you think there is or there should be something like a single international law? Is that even possible? Or rather, as David Kennedy put it, do you think there are or there should be different international law in different places?
The world is indeed a very diverse place, and that therefore the universality of international law for many is a kind of not only an ideal, but maybe the only way to actually have international law, to have at least some universality. Because if one would abandon that, then it's very easy to say that these states have their own international law, and those others would have their own international law. But I think at least since the 20th century, we don't do that anymore. International law has a strong sort of universalist ethos. I must also say that historically this hasn't always been the case. So, for example, Europeans in the 18th and 19th century kind of said that international law only applies between them, and it doesn't apply in the same way everywhere. So the way international law nowadays deals with this diversity, one of those ways to deal with it is regionalism. So while having universal international legal norms, ideas, treaties, there is always a regional component as well. I already mentioned the Council of Europe. So for example, the Council of Europe has developed the European Court of Human Rights, which is a regional kind of strong human rights court, and not every region has that. But there are other regional norms as well. For example, already in the 19th century in Latin America, jurists said that they have developed some of their own legal norms and ideas. But I think the challenge, the politically important challenge, even when accepting this diversity, even giving space to regionalism, is to see that we don't throw the baby out with the bathing water, because I think that in those core issues like prohibition of the use of force, international community should work with the assumption of universality, because often those conflicts, those tensions would also emerge between countries belonging or perceived to belong to different groups of countries. But if we would abandon the idea that common standard ties them all, then we can forget about actually putting pressure on those states.
Thank you. So, if I understand correctly, the answer is a little bit you need both for different things, and both can and maybe should coexist. Do you agree with that?
Well, the idea of different international law in different places, which is a word of Kennedy, I think it's a very important question and also a very dangerous point. As I already said, we need universality, and it's very difficult to say that you have different national approaches to international law. We need a kind of cohesion. I think a way to address it is to distinguish between the negotiations of international rules and the implementations of international rules. At the stage of negotiations, of course, we need to be as inclusive as possible. You need to take into account of all the diversities, all the legal cultures. Also because, for instance, when you negotiate a treaty, you need to be sure that when the treaty will be adopted, it will be implemented in every country and it will be compatible with every legal culture. So at the stage of the negotiations, diversity is key. You need to be sure that what you will adopt will be compatible with all legal cultures, all legal traditions, all national approaches. Then, when you have the international rule in force, here I think you have only one single rule. You cannot say that you have one rule and different national approaches to the same rule. That is very problematic. And unfortunately, today you have some legal scholars calling from what they call comparative international law, the idea that you would have different national approaches to the same international rules. That is, I think, very dangerous. So to me, the balance to be found is to try to be as inclusive as possible when you negotiate international rules, and then when there is a rule of international law, you need to be as universal, as cohesive as possible to be sure that it will be implemented, and it will be the same rule for all states which are parties to this rule.
All right, that maybe takes us to another topic, which is the topic of equity. So, of course, equity or some level of equity is important to maintain some stability, but at the same time, we see huge inequalities in societies and between states and so on. As international lawyers, what do you think about that? Does international law recognize and work enough, in your opinion, with these inequities? We can start with Mathias.
Well, to start with, I think there is no doubt that international law is not equitable enough. That's, to me, crystal clear. At the same time, equity is not the same thing as a law. And the International Court of Justice said it quite repeatedly that equity is not law. These are two different things. This being said, in the recent years, we are assisting to some extent to a consolidation of a kind of general principle of equity, which may perhaps in the future result in the creation of a real rule of equity. And I will just take two examples of this recent evolution. The first example is a work of the IAS on sea level rise, where last year we heavily debated whether or not there exists a general principle of equity in international law. And there are strong arguments today to be made to say that in some areas, at least of international law, there is a legal rule of equity which has to be applied. And in particular for sea level rise and small island states, they may have a right to equity and to have some rights to be protected when they are facing, for instance, the disappearance of their territory. The second example is a recent conclusion last June of the BBNJ agreement, the agreement on biodiversity beyond national jurisdiction, which is a huge achievement in the law of the sea for the protection of the high seas. And in that draft, in that treaty, this is a treaty, you have an article, which is Article 7, on general principles and approaches. And in this Article 7, you have a reference to the general principle of equity. So this is a good precedent of a treaty provision which refers explicitly to the principle of equity. So, of course, this is still very exceptional to have this kind of reference, but I think it shows that more and more often today, there is the need to have equity not only as something that you can use to assess if international law is just enough, but which is also integrated in the corpus of international rules, at least in some areas of international law. And I think this is something which is very important for the future of international law.
What about you, Lauri? Do you agree with that?
I think equity is really important, fascinating problem in the world. It also we have to ask the question when after they put it in a treaty, what does it mean? Because then it must be interpreted what it means specifically. It can be a kind of guiding principle, but debates will probably constantly continue about resources, distribution of resources, and I agree with the starting point of Mathias that I think you'd have to be blind if you don't see that there isn't enough equity in this world. I think it's to some extent both within societies, but also between states as well. And the difficult problem is that not all of this is man-made. For example, think of the impact of climate on the lack of equity. Just in some places it is easier to develop agriculture, for example, when the climate is more moderate, for instance. But historically, the record of international law in creating equity has been, I would say, modest. One attempt was made in the 1970s when developing countries in the UN General Assembly started to talk about something called new international economic order. They wanted more redistribution also of resources, that development assistance wouldn't be just a gift but some sort of obligation, things like that. But it's interesting how many of these efforts kind of they did not have a very big success, at least not immediately. So equity in that sense is one of the ideas that shapes international law, that international law reflects. But at the same time, international law is also influenced by the ones who do have power, by the ones who have resources, and it seems that this desire to share resources is also often limited among humans. It's connected to this problem of regionalism as well. I think that in some ways, just as humans find it sometimes easier to be solidaric with their relatives than just strangers, then it's the same, it seems, with geographic groups of states. So I don't know, and sometimes for let's say rich countries is easier to do some sort of redistribution in their region, like for example in the EU, although the sums that developing countries also give to development cooperation, developed countries, what they give can also be significant.
Thank you so much for your very interesting answers. As for the last question for today, I thought maybe we could go back to more applied topics, maybe. So I wanted to discuss a little bit this trend that we're seeing in recent times of having recourse to international courts and tribunal to address issues that are normally addressed by international organizations or interstate cooperation. Things like the proceedings on climate change or cases submitted to the International Court of Justice in relation to Ukraine or Gaza. How do you see this? Do you think this is some progress of international law that is now able to address and help with these issues, or is it rather a failure of the international community to take appropriate measures and cooperate effectively in these topics?
I think what we can see in our time is indeed the attempts of many states to use all these opportunities that international law has to offer through its institutions, through international courts. One key feature of international courts is that their jurisdiction is not endless, it's not automatic. So states have to prove that the court even has a jurisdiction to look into it, and the plaintiff state, the defendant state, so to speak, they are often not interested in having this kind of dispute in an international court. And some of those advisory opinions like that have been generated by the UN General Assembly, for instance. They seem to be also a reaction to this, that the jurisdiction of international courts is limited, and they want to kind of bypass it. But I think the results are mixed to an extent, because the name says it, advisory opinion. Because if you are a powerful state, for example, Security Council's permanent member, I don't know, the UK in the Chagos Islands, it is not that they hurried to implement this judgment that in the advisory opinion. Or let's take this other example of the climate change. If we think of this problem politically, that this is the crisis that humanity is facing, we don't do enough, we sometimes disagree what we should do, what we should give up to maybe prevent the worst case scenarios happening, but it's debatable what role courts can play in that. I think courts are used to, also domestic courts, to put pressure on governments, but in the end, even courts' power in some ways is limited. So it has to be an effort not only by courts, but by societies in large, and by governments and everyone.
Thank you. What do you think, Mathias, what do you think is the role of the courts in these issues?
Well, of course, if I were a domestic lawyer, I would not be surprised by the fact that subjects of international law comes to jurisdiction, court and tribunals, to have their claims adjudged by these courts. So the question is to what extent the specificities of international law has an impact on the recourse to adjudication. For many decades, recourse to court and tribunals was in fact mainly the weapon of the weak. When you cannot negotiate, when you don't have bargaining powers in front of a big, powerful state, then you can have recourse to court and tribunals, because here international law will give you what you cannot have through negotiations. I think what is changing today perhaps is that court and tribunals are used to put some political pressures on other states, when in particular international law is not taken enough seriously. And the examples of climate change, I think it's a very good example, because you have the Paris Agreement of 2015 with obligations in the Paris Agreements. But in fact, these obligations are perhaps not taken seriously enough by many states. Hence the need to have court and tribunals making rulings, advisory opinions on this topic, to oblige states to apply these obligations, or maybe to go further than these obligations. So you have a mix of political goals and adjudication at the same time. As Lauri said, I think there is some danger perhaps in this, because you can maybe create false expectations for people. When you say, I will go to the ICJ to claim this and that, and in fact international law is not what you claim it is, then there is a risk to create false expectations, which could be damaging perhaps for the states themselves or for international cooperations. So in a nutshell, adjudication is good, but you need to use it with wisdom, so to speak, to be sure that it will achieve what you want to achieve through adjudication. With regard to climate change, you have, of course, the ICJ, the Tribunal for the Law of the Sea, but today we will have a ruling from the European Court of Human Rights on the Duarte case about climate change. So it's not only a question of international court and tribunals, but also, again, regional court and tribunals. And to me, that is what is international today. This is a combination of many different initiatives at the universal and regional levels before court and tribunals or before other fora. And this is these combinations which today creates international law. So the international is today much more dynamic than it used to be in the past, and we need to adjust to this new reality, including to this new use of education by states or individuals.
Thank you very much to both for being here today. This has been a fascinating discussion, and it's just the kind of activities and spaces that we want to open at the Paris IAS, both because you are great researchers from the Paris area and from an international university that we manage to bring together here at the Paris Institute for Advanced Study in these beautiful rooms that the mayor's office lends us, but also because the topics are extremely relevant to today's societal challenges, and that's something we consider very important as well. We have a whole range of talks and activities that are concerned a little bit with those issues, trying to create the links between international and more local based research. So thank you so much for being today here again, and we hope you keep in touch and keep collaborating both while Lauri is here and afterwards as well. Thank you.